Hi, everyone. Today we're diving into a topic that I think many foreclosure investors, HOA buyers, and even real estate attorneys may not fully understand yet, the growing issue surrounding HUD reverse mortgages, foreclosures, and the unexpected complications some investors are running into after purchasing properties at an HOA or foreclosure sale. So, joining me today is my friend and also my attorney. It actually is my attorney, as it so happens, but he's also attorney to many other people as well, and that's Jeff Harrington of Harrington Legal Alliance. Jeff has been digging deeply into what he believes are some very serious legal and procedural issues involving non judicial HUD foreclosures, investor notice, title complications, and the broader implications for the distressed property market. So, over the course of this episode and our follow up discussion next week, we're going to break this down in plain English so investors can better understand what's happening, why it matters, and how these situations may affect future foreclosure and HOA buyers throughout Florida and beyond. Jeff, thanks for joining me. It's a pleasure to have you here.
Hey, donate. Good to see you.
Likewise. So, Jeff, before we get into the legal weeds, can you explain in simple terms what the issue actually is and why you believe investors should be paying attention to it?
All right. Well, I will try to keep it simple. Really, what I'm focused on here, what I'm hoping to talk to about and talk to the group about, and explain and make people aware of, is the HUD foreclosures, non-judicial foreclosures that we're starting to see crop up now suddenly. Just after that, I guess what the real estate crisis started in 2008, and I haven't seen any of this federal foreclosures, even though the act has been in place for a while now. We're just now starting to see them, at least in my practice. I'm just now starting to see them, within the last year, and they're popping up all over the place. And so I wanted to explain to the group, what a non-judicial foreclosure is, how it is that in a judicial foreclosure state like Florida, we're seeing these, and explain a little bit about how it comes up. I mean, I've only seen it in the context of reverse mortgages. That seems to be, the normal profile. Let me just stop there for now.
Okay. So, for people who may not fully understand reverse mortgages, could you briefly explain how a HUD-backed reverse mortgage works?
Well, I can give you the broad strokes. I mean, I'm not a mortgage broker, but as I understand it, reverse mortgage, it's different from a regular mortgage in that, well, it tends to be for people who are, up more advanced in age, and maybe they can use the cash now. They have like their house, which is their asset, their primary asset. They could use some cash to get them through their, golden years, and then they're not too concerned about what happens with the house after that. So in that context, there exists something called a reverse mortgage, where a lender will actually pay the borrower. So it's kind of backwards. You got a lender and you got a borrower, but instead of the borrower making monthly payments to the lender, it's the reverse. The lender's making monthly payments to the borrower based on the equity in the property. And then when the borrower dies, I think essentially the bank either gets the loan paid off or they get the home, in simple terms.
What makes a HUD reverse mortgage foreclosure different from a traditional foreclosure that investors normally see in Florida?
Okay, now we're getting to it. So if you're a Florida investor, if you purchase at auctions, then what you're used to seeing is this whole judicial process. It's a lawsuit, right? It's a foreclosure action that ends with a an auction, and it's all supervised by the courts. And there's lots of notice, and there's motion practice, and there are orders, and the whole thing goes along in the normal fashion that we're used to with any kind of lawsuit. All right, now. Florida is a judicial foreclosure state, but about half of the states in the country are what we call non-judicial foreclosures. Now that's an entirely different beast. So there is no lawsuit. There is no, there are no motion practice. There's no attorneys involved usually. There's no orders. There's no judge. It's, I mean, I'm from California. That's a non-judicial state, so that's the one I'm most familiar with. It's really just based on notices. Like one notice goes out. It's pretty crazy if you're used to the judicial process, how quick and easy it is for a lender to foreclose in a non-judicial state is pretty alarming. Um, like one notice goes out and a date is set for the auction of your property, and that date comes and goes and the title just gets passed. Like that's it. It's over. You don't really get a chance to present any arguments. You don't get to, get an accounting, for example, from the lender. Yeah, it's a lightning rocket type of event.
When did you first start to realize, though, that there might be a larger issue developing here?
Well, okay, so the first thing it just shocked me and scared me straight when when I saw a non-judicial foreclosure happening here in Florida. And so I got this piece of paper and I was like, "Nah, this has got to be wrong. They don't understand that this is a judicial foreclosure state." Well, what I didn't understand is that there's a federal act that's been on the book now for a few years. It's not brand new. I think they're just starting to use it. But it's been on the book. Let's say it's called Single Family Mortgage Foreclosure Act. And what it says is that the federal government is preempting all the states. So it doesn't matter whether the state is typically a judicial foreclosure state or not. This act preempts all of those state laws. And now, for purposes of these HUD foreclosure actions, they're all entitled to not this non-judicial process, which, as I mentioned, is very quick and dirty. Like one notice goes out, it has a date on it, and when that date comes and goes, you've lost title.
Okay, so I mean, that's really interesting. I personally haven't dealt with that many reverse mortgages in my career, but was there a specific case or client situation that made you stop and say, "Hey, wait a second, something about this just doesn't feel right"?
Yeah. Well, this first experience that I had with it was a client, and I think he probably came from Property Youngin. It's how he probably first learned about me. Um, and he sent over this notice to me, and I was like, "Well, okay, I know what this is because I'm from California. We have non-judicial foreclosures there, but it has to be wrong." And then I did the research and found out that wow, when it comes to these particular loans that are owned by HUD, owned by the federal government, they have the right to do to this non-judicial process. Okay, so that was a shock to the system, total wake up call for me. I didn't even know that that was a possibility. We haven't seen it, low these 17 years or so since I've been doing foreclosure practice. Um, Now, why did it start to smell funny? And what made me think that maybe we need to push back? Maybe something needs to be done here. Well, there are a few things. So when you take out a regular loan and you get a mortgage on a property, that's a clear and transparent process in the sense that you know the amount of money you're getting, right? If you take out a $100,000 mortgage, well, you get $100,000 to do with as you please. Not so with a reverse mortgage, because remember that really just depends upon how many months you live after you take out that reverse mortgage, because now you're getting monthly payments, for as long as you live, but nobody knows the full amount of money that you're going to use before you actually die. And then the loan is terminated, and either the bank gets paid or they take your home. So that just from a philosophical point of view, you know, made me perk up. These the ones that I've seen, um, we're seeing these loans foreclose for a specific amount, and it looks to me like it's an amount that was predetermined when the loan was originated, and based on the facts that I became aware of through my client, I couldn't see any possible way that this borrower could have used that amount of money. So that's what I guess first made me perk up is that these loans, one, they just foreclose on it like that. There's no judicial process. There's no possibility of the borrower or the borrower's attorney then to dig into and ask questions of and propound discovery on lenders. I mean, there's no possibility of doing that, with one exception that we'll talk about. Um, and everything is just behind the curtain, right? Who knows how much money the borrower actually, actually used before they passed away. So, just in my sense of right and wrong and equity, none of that squares.
Hmm. It's interesting, but so let's talk about the typical investor. Someone buys a property at an HOA or a condo association foreclosure sale. What do they normally believe they are purchasing?
Well, I guess it might depend on how sophisticated the buyer is, but hopefully they understand that that there can be levels of interest holders, stakeholders. So, usually the paramount um, lien holder is going to be the first mortgagee, right? So if you're buying at an auction where the plaintiff is the first mortgagee, you know, by and large, with some exceptions, you should be in pretty good shape. You should, if you're the successful bidder, take title free and clear. Um, but obviously, if you're buying at a second mortgagee's foreclosure action, then you're going to be subject to the first mortgage. And then HOA associations, similar kind of analysis. They're now even below the second mortgagees. So if you're buying at their auction, you could be subject to one or more mortgages. Um, Tax deeds are a little different. That wipes out most everything. But so I guess it just depends on the situation.
Sure. Why do you think that many investors assume that they can identify the major risks through title searches and public records?
Well, hopefully they're using Property Onion, or if there are any other companies out there that offer a product like Property Onion, hopefully they're using that. I don't know if title search is the term you use, like encumbrance, search. I forgot what you guys call it, but it's a great product that basically provides a report of all the liens that are affecting the property, affecting the title. So that is pretty good, and I won't candy coat it. Like, I'm not here saying that my clients who find themselves faced with a non-judicial foreclosure, that they haven't done anything wrong. Well, you know, they probably should have discovered that reverse mortgage. In the same way that all the rest of you, when you're bidding at auctions, you should also do your diligence and know whether there are any paramount liens or not. So in that sense, it is the same.
Sure. In these HUD reverse mortgage situations, where does that process potentially begin to break down?
So to me, it comes down to this lack of transparency. It's the double whammy of there's no lawsuit, so you don't have any chance as the borrower. Or now I guess you'd be the successful bidder who's now being foreclosed out. Maybe let's start with that. Let's set the scene. So here's the scenario that I'm concerned about, and that my lawsuit is set up to address. You, the investor, go bid at an auction. Sadly, tragically, you didn't notice that there was a reverse mortgage. And let's say you're bidding at a second mortgagee's auction or an HOA's auction, which that's more typical, right? And you didn't notice that paramount lien, that mortgage there. And so now you bought the property, and suddenly you get this letter in the mail saying, "Oh, by the way, there's a reverse mortgage on this. Congratulations on buying this property at the association's auction, but there's this reverse mortgage lien on it, and within 3 weeks we're going to take title to the property." Okay, that's the scenario that I'm set up to address, because yes, you did make a mistake. You should have become aware of that reverse mortgage and avoided bidding at that auction, or make arrangements to pay off the mortgage. Make your adjustments, make your bid accordingly. But what I don't like is, let's say you do want to negotiate, you do want to talk, you do want to make some sort of arrangement so you don't lose the property. You probably paid a good amount of money to win the property at the bid. And so rather than just walk away from it, you would like to pay off the reverse mortgage that was left behind. Well, how are you going to do that? The way it is right now, and this is the part that does bother my sense of right and wrong. The way it is now, you just have to take the number they give you, and it's going to be a big number. It's going to be whatever number HUD has determined is the value of that loan, and you don't have any way to double check that. In a regular foreclosure, it's a lawsuit. So you get your attorney propounds discovery, you make motions, you can have depositions. We do all these things. And you can get to the bottom of just about everything, the whole history of that loan in many cases. You don't get that opportunity at all in a non-judicial foreclosure. There's zero transparency based on the facts that I was aware of with regard to this case and now several other cases. I know that number's wrong. I know that there's no way the borrower could have, you know, used $500,000 before they died. They passed away, a year and a half later. Um, so so that's where things start going wrong in my mind. Look,
Mm,
okay, as an auction bidder, you made a mistake, but you should have a fair opportunity to salvage this project by paying off the correct amount, and you're not given that opportunity.
mm. Look, you've mentioned that some of these HUD foreclosure processes are effectively invisible to the marketplace. But
Mhm.
what do you exactly mean by that?
It's a letter. That's all it is. You get a notice. Nothing gets filed with any court. Um, Nothing gets recorded in the public record. I mean, we're not talking about the mortgage itself. The mortgage obviously does get recorded at the county courthouse, and that is in the public record, and that's what you missed when you bid at the association's auction. But as far as the foreclosure itself, it's one letter, and that's it. There's a date in that letter.
Yeah. And why is the timing of HUD's action so important in these disputes?
They seem to have an uncanny ability to employ this non-judicial foreclosure after there's another owner in place, like after one of these real estate investors has come along and purchased the property unwittingly. um, that's when they seem to bring these actions. Now, that's an interesting question because I have now since educated myself a little bit as to how this law works. And there is a requirement that there's a regulation um, that HUD is supposed to foreclose on these mortgages like within 6 months, like shortly after the death of the borrower, which only makes sense, right? It should be that way, but they don't. They allow the mortgage to just sit there for years. And so then once, one of the investors comes along and buys the property, now there's all this accrued interest. Um, there's lots of things one can do with accounting, so they can almost make the payoff number whatever they want. I mean, I'm exaggerating a little bit, but only a little bit. There's lots you can do with, compounding interest and penalties and legal fees, and they throw all that in there and they give you whatever number they want to give you.
Hmm. You know, one of the concepts that you've mentioned is the idea that HUD may already have become the equitable owner before the HOA foreclosure auction even occurred. Can you explain what that is in plain English?
Okay, so remember how these things work in terms of priority, right? So you've got let's go back to an association example. The association can't foreclose out a superior lien like a mortgage. The association auction comes and goes, and those mortgages stay in place, right? You're stuck with them if you become the buyer. However, that association auction will strip the owner of title, right? So what happens, and this was the very first case that came to me. What happens if HUD actually does foreclose? They use this non-judicial foreclosure process and they foreclose, and now they then are the owners of title, right? It's a foreclosure just like the ones we're used to here in Florida. Once you foreclose, Either a third party bidder gets it or the lender takes it back, right, and becomes the owner of title. So if the non-judicial foreclosure goes through and there is no third party bidder, HUD then becomes the owner of record, becomes the owner of title. If subsequent to that, the association foreclosure occurs, well, HUD then gets extinguished just like the previous owner, right? Just like the borrower would. And that then would give the third party bidder free and clear title.
Hmm. This is all very interesting and slightly a little bit complex. And so,
All right.
saying that, how can the ownership potentially exist in equity, even if the deed hasn't yet been recorded publicly?
Uh, yeah. So now we're getting to it. Okay. Well, if you thought the previous part was complex, I apologize in advance. Look, understand. We're used to, the regular person is used to thinking of what gets recorded in the county record as being, the legal mechanism. But in reality, that's not. Let's say, for example, let me give you an example here. This might be easier to understand. Let's say you sign a mortgage, um, but the mortgagee, the lender, fails to record that mortgage. Okay, so does that mean you're off the hook? That mortgage doesn't exist? No, it doesn't. That mortgage you signed, it's a contract and it's valid and enforceable. The only thing that has changed is that the world hasn't been given notice. That's why we record things in the public record. That's why you put things in, you take things down to the county clerk and record it. So you're putting the world on notice. It's really just a notice mechanism. It's not the filing of that document itself that has the legal effect. No, the moment you put your signature on that mortgage, that made the agreement binding and enforceable. The recordation just gives notice to the world. And so nobody can then come along and say, "Oh, how was I supposed to have known that that mortgage was there?" Um, let me stop. Let me pause there because I'm sure we're going to need to hash this out a little bit more.
Sure, but why is a delayed recording such an important issue here?
Yeah. So I guess my argument is HUD doesn't get to have it both ways, right? You don't get to have a non-judicial foreclosure that's set for within 3 weeks of when that letter shows up, yet not record the deed for years if you want, until some other poor sap comes along and becomes a successful bidder, and now you pop up out of the woodwork and say, "Hey, you got to pay off this mortgage." No, if you my argument is that if you did that non-judicial foreclosure, you then, whether or not you recorded that deed, I know you didn't record the deed, but that in and of itself is not relevant. That's not the determinative factor, is the recording of the deed. You foreclosed. You're entitled to do that. Your own little federal act says you're entitled to do that. So then you became the owner of record on that date that you put on your letter. And if there are any subsequent foreclosures, well, you got extinguished out, just like the rest of us would be extinguished out, right?
Hmm.
That's my argument.
Okay, so from your perspective, is the concern that HUD may effectively be able to choose when it wants ownership to matter and when it doesn't?
Exactly right. Yeah. It seems to me like it's already a shockingly favorable statute that they've given themselves. They've given themselves the best of both worlds. Sorry, let me explain that because I've said it a couple of times and I mean something different now. So, as I said, the country's divided roughly in half. That half of the states are judicial foreclosure states, and half of them are non-judicial foreclosure states. Well, the non-judicial foreclosure states, almost always there's a trade-off. Like they recognize that this is very cheap and easy, quick process, and so there's a trade-off generally. So, for example, if it's a non-judicial foreclosure state, well, then they can't go after the deficiency. You know what I mean? That, if the value of the property is not sufficient to cover the amount of the mortgage, then there's a deficiency. There's that shortfall. Um, in Florida, which is a judicial foreclosure state, the lender is then allowed to turn around and sue the borrower for that deficiency, for that difference. But the trade-off, what the non-judicial foreclosure states give up typically is that right to go after the deficiency. So it should be a little give and take. If we're going to make it so quick and easy and painless for you, you don't even have to file a lawsuit. You don't have to incur any expenses. You just take the title after the date that you've determined. Then let's at least have a trade-off where you don't get to go after a deficiency judgment. So when I say that the federal government has now given themselves the best of all possible worlds, it's because they're allowed to do a non-judicial foreclosure. They're allowed to go after deficiencies. I mean, if you get into it, you just see that they've taken all the best aspects of every state and given it to themselves in the form of this Single Family Mortgage Foreclosure Act.
So this is what you mean when you say HUD may be getting the best of both worlds.
And giving themselves the best of all worlds. So, if on top of that, the fact that they've given themselves such a favorable act, if on top of that, they get to do the foreclosure and then decide when it is they want to own the property, well, I say that's a bridge too far, right? that's
Sure.
that's where it shocks my conscience.
How dangerous is this for foreclosure investors if your concerns turn out to be correct?
Well, hopefully, I mean, listen, going back to what we said before, hopefully you are using some sort of a product, or you're very savvy and you're doing your own diligence, and you find out about these reverse mortgages before it's too late, and either make arrangements to pay them off or don't buy that property. So starting with that. But if you do find yourself in the situation, the unfortunate situation where you bought the property, you're the successful bidder, and now you find out about the reverse mortgage. And now you got one of these letters saying that, well, within 3 weeks, title's going to pass. We're just going to strip you of the title. Um, you, in my opinion, should have an opportunity. You're the owner, right? You're the owner of record. You should have an opportunity to ask some questions and to examine the order of events and see if maybe, just maybe, you are the owner in fee simple, free and clear, because HUD foreclosed previously and now they've been extinguished by the association foreclosure or whatever. And if not that, if that's not the case, then you should be able to ask some questions about the accounting, right? What is the true value of this mortgage? And as it stands, there's no way for you to do that. I'm not sure if you're ready for me to talk about that yet, but there's only one mechanism we have to be able to ask any of these questions. So let me wait till you're ready.
Could this affect condo association foreclosures across Florida?
I mean, I just use that as an example. I suppose it could come up in other contexts as well. It could come up in any other kind of foreclosure. I suppose not in a tax deed, because that would extinguish the reverse mortgage. But there could be other types of foreclosures. It could be a second mortgage foreclosure.
Sure. I mean, that that's exactly what I thought, that maybe, could this impact tax deed investors or other distressed property buyers as well?
Yeah. Yeah. So I guess associations are the ones that happen most frequently. So they're likely to be the ones that get caught up in this. And it may be the case that the reverse mortgage lender would not allow a second to be in place. I don't know. That's a bank by bank determination.
Sure.
But it might be that they often require the second to be paid off. So it's probably likely to come up most often in the association context. I hadn't thought about that before. That's probably true.
Are these isolated incidents, or do you believe there may be many investors who have encountered similar situations?
There's got to be many. I'm just sure of it. I mean, I'm a relatively small practice. We're just here in West Palm Beach. We practice throughout the state, but if I have like 5 or 6 of these, there's got to be a bunch out there.
Yeah, sure. I mean, do you think that most attorneys and title professionals even fully understand these issues yet?
I would be surprised. First of all, I did the research and couldn't find any other lawsuits against HUD. That's what I'm doing. Um, I was just certain that somebody must have started challenging these things by now, but I'm not finding any. So that leads me to believe that nobody's nobody's decided to take this on yet or really dig into it. If you're from a judicial foreclosure state like Florida, you probably just don't understand what the hell's going on. I only recognized it because I'm from California, and so I know what those letters are. So,
Yeah.
I don't know, but it's quite possible that, yeah, nobody knows about them or what to do with them.
To be fair, I mean, what is HUD's side arguing in response to all of this?
Okay, so they have a local attorney that they call a foreclosure commissioner. And that's the party who sends out the letter. And so that's the party you can contact. I have done so. And I have engaged this individual who's a well-known, attorney that I would expect knows everything there is to know about real estate and foreclosures in particular. And I didn't get any satisfactory answers to my inquiries. I didn't get any persuasive rebuttals to my arguments. Um,
Mm.
so I don't know. We'll see once the gloves are off and the litigation is flying. That's when I expect the heavy hitters are going to come in because if I win this lawsuit, that's going to be very significant.
Well, HUD's position seems to be that the investors simply bought subject to the mortgage risk. So, why do you believe that analysis may be incomplete?
Yeah, and this is where maybe we're going to run into. This will be interesting. This is all pioneer territory, right? So we don't know how this is going to play out, and I suspect that the law has not yet been established in some of these questions. So I'm doing my analysis based on Florida law, basically, the notion that once you become the owner of record, then if there's a subsequent foreclosure, you as the owner of record get foreclosed out. There's one other scenario that came up as well. We have good reason to believe that one of these reverse mortgage borrowers did a deed in lieu of foreclosure, if you know what that is. Has the same effect. It would, if accepted by HUD, it would make HUD then the owner of record if they accepted this deed in lieu of foreclosure. So same effect. It put HUD on title prior to the subject association foreclosure. Um, So I guess I'm basing my analysis on existing Florida law and just common sense, basic legal principles. There's no reason why it would be otherwise. Uh, if the federal government is going to make a special rule for itself, it will need to do so. It hasn't done so yet, but I suppose, they're going to try.
Is this partly becoming a larger debate about transparency and notice?
I'm going to try and make it a larger debate about those items, right? Because it just, I can't make allegations. I don't want to make unsupported allegations, but I just can't see how these numbers could possibly be accurate. Setting aside the issue of did HUD become the owner of record before the foreclosure, um, as an entirely separate matter, I just don't think we're getting good accounting. I don't think the numbers that HUD's giving us is the correct number.
Do you believe the current system gives, let's say, ordinary investors enough practical visibility into these federal foreclosure actions?
I mean, to be fair, again, we have to go back to we're separating two things, right? The investor, the bidder, they did mess up, right? They should have noticed that reverse mortgage. But you know, having said that, once the harm is done and you're just trying to salvage the project, not lose your shirt on the deal, you should be given a fair opportunity to do that, in my opinion.
Mm.
I don't think you can just say buyer beware. No, because if the payoff amount is wrong, then the payoff amount is wrong. That's not a buyer beware issue. That's a fairness issue.
Mm. Look, in the next episode, we're going to go and we're going to get deeper into the legal doctrines involved here, including merger doctrine and equitable ownership, and why you believe this issue could eventually grow into a much broader litigation. So before we wrap up today, what would you want investors listening right now to start paying attention to immediately?
Well, as always, I mean, this is nothing new, but first of all, do your diligence. Know what, don't start throwing hundreds of thousands of dollars, sadly, in some cases, into these auctions unless you know what you're doing. Work with Property Youngin. If you don't know what you're doing, work with Property Youngin. Um, get that report. If you're not sure what the report means, send it over to me. I'll interpret it for you for a good rate. Um, but if you find yourself in the situation where you're getting a letter from a foreclosure commissioner saying that they're foreclosing a reverse mortgage that's owned by HUD, then call me because I've put together a group of people in your situation, and that has a couple of advantages. One, you can divide the fees, right? So you're not just paying me to bring an action on your behalf. You get to split the fees with a whole group of people. And two, it's likely to carry a lot more weight with a judge, right?
Yeah, sure. Well, Jeff, this has been an incredibly interesting episode, because I think a lot of investors listening today are probably hearing some of these concepts for the very first time. And in the next episode from Spain, where you're going to be, we're going to go even deeper into the legal theories behind these cases, the practical implications for investors and associations, and why this issue may end up becoming a much larger than many people currently realize. And of course, if anyone listening believes they may have encountered a similar situation involving a HUD reverse mortgage foreclosure, HOA foreclosure, or title dispute connected to one of these properties, we'll place Jeff's contact information below so people can reach out and share their experiences. Jeff, thanks once again for joining me, and thank you everyone for joining us today.
It's always a pleasure, Tony. Thanks to everyone.